Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law. And this will be what we're commenting on today. Well, today I am probably sitting on a beach chair somewhere, soaking up some tropical sun. And I left these videos to run while I was off on my cruise vacation to the Panama Canal, so that there would be something that would be worthwhile to watch while I was gone. Hopefully, you're enjoying things so far. Today, I want to go into a little bit more of my tutorial mode, and I want to talk about landlord and tenant law. And it's an important area, at least from my perspective, to talk about. I may have mentioned on here before that my mom was a bit of an alcoholic, and as a result, she was really bad with money. And as a result of that, she was frequently in a situation where she had to move, usually fairly quickly, and hopefully disappear so that she couldn't be sued. Um, these kinds of things happen, and you'll learn a lot watching people go through this. And eventually, I was able to help my mom get back on her feet, and she, in the last days of her life, she was probably the best tenant anybody ever had. At one point in time, she actually started managing apartments for people, which again was really a wonderful thing for us. The area of landlord tenant law is one of those areas that is very peculiar to each state that you're in. So I'm going to go through this, but I do want to emphasize here, and again, while I'm doing this, that this is the kind of thing that is really controlled by state law, and you probably need somebody to help you with it, like an attorney who knows what the state law is. So we're diving into a topic that affects millions of people. And whether you're renting an apartment or leasing out property, knowing what your rights are and what your responsibilities are is really very important. Some might even say it's crucial. The American dream, of course, is home ownership, but for many people, that dream is out of reach, particularly in their 20s. Now, when I was, I guess, 29 years old, I bought my first house. I bought it contract for deed, which I would never do again because the danger is that the person you're buying that house from goes into bankruptcy. Well, your contract can be ripped apart by the bankruptcy trustee and you've just lost your investment. And there's really nobody that you can go back and sue in that situation because they're protected by bankruptcy law. So you have to be really careful about how you buy your first house. I got lucky with mine. Don't get lucky with yours. Do it the right way. The fact is that when you get ready to buy a home, one of the first things that people are going to look at in terms of deciding whether to loan you money is how well and how stable you've been in terms of being a renter. Because most people rent a house or an apartment prior to going out and buying their first home. And because you're going to be winding up renting something somewhere down the line, it is a good idea to understand and know what the law says about that. Now, as I mentioned earlier, the law here is very generic. It covers principles that would be applicable in most states, but not all of these principles will be applicable in all of these states. And that's why it's very important to check with a lawyer before you enter a lease of any kind. And if you are thinking of leasing property, you need to talk to a lawyer to draft the lease so that it will comply with local rules and ordinances in some states. If you put a provision in your lease that you believe protects you, it can wind up costing you money if the state comes in and says you committed an unlawful act in the leasing of that property. Now, usually that's more like states like New York and on the East Coast, but it can happen, and you have to be really careful about how you go about leasing or renting property people. The law in most states gives landlords and tenants both specific rights and obligations. The landlord, for example, has a right to allow you to have the quiet enjoyment of the premises. And what that means is he can't keep coming over every day to inspect the premises to see if you're keeping the house clean. He has to let you live in that house and have the quiet enjoyment of living there. On the other hand, that doesn't keep him from being able to come in and inspect the property while you're there or whether you're not there. If you are if the tenant is in possession of the property, then the landlord can serve notice that he is going to conduct an inspection. And they usually do that as a matter of courtesy. And in most states, I think it's actually required. But if it's not required, it's just a good idea anyway. And they will come through and inspect and make sure that, the appliances are working and that you don't have, fire hazards, 15 extension cords plugged into one outlet, that kind of thing. Because they have different rights and different responsibilities, landlords and tenants are always going to be at least in minor conflict over certain things. And that's why the lease is very important. In order to get started, let's talk about some key terms. Now, I've mentioned it before, the landlord is the person or company that owns or leases the property being rented. Now, usually it's going to be the owner of the property, Acme Corporation, right? They own 350 apartments in this big building, and they're renting them out to whoever comes by. Well, sometimes there is something called what's called a real estate investment trust, or a REIT, REIT. And the REIT is itself a trust and owns the actual property. But because it's a trust, it does not want to act as the landlord. So it leases the property to a management company, and the management then, in fact, subleases the property to you. And those situations are a little bit different because the landlord is itself beholden to the owner of the property. But in most cases, when you deal with a trust or a landlord, you are dealing with the person who owns the property. The tenant, of course, is the individual or group renting the property from the landlord. Now, just like individuals can rent, Mr. Jones goes in and rents from Acme, so too can businesses come in and rent. No matter how a property gets rented, it is almost always done with a lease. Now, a lease is a legal contract that outlines the terms under which a tenant rents property from a landlord. Because it's a binding contract, you should take care to read it very carefully. Often, corporate leasing agents will say something like, "It's our standard contract," and they do that as an excuse not to answer questions that they probably have no ability to answer anyway. But if you sign it without understanding it or knowing what that term means, you are still going to be bound by it. And if someone says, we never enforce that clause, you can bet that they certainly do enforce that clause when they need to. Otherwise, it wouldn't be in the lease. So, in terms of leases, the key things: read them, understand them, ask for explanations, and remember that any explanation that you are given about a contract doesn't become part of the contract unless you incorporate it into the contract. And so if they give you a note saying, "No, we're not going to enforce the $50 pet deposit if all you have is a salamander," and then you later wind up, acquiring a beagle, uh, you can be sure that they will enforce that clause even if you didn't understand it, even if they didn't make it clear. And even if they just wrote that as a little note to you, it doesn't modify the contract unless it specifically says that it modifies the contract. So again, these are areas of the law where people get tripped up, and it happens all the time. The next term, security deposit. That is money paid by the tenant as a guarantee against damages or unpaid rent. Now, usually, most people hold it as a remedy against damages. So if you get a clean apartment when you move in, and when you move out, you leave a clean apartment, most places will return your deposit. And if, you're there for 4 or 5 years and the place is now going to need to be repainted, that's usually considered fair wear and tear. It's usually not right to charge you to have the apartment painted if you didn't do anything to damage the walls. So the security deposit is there in case you cause what the legal term for it is waste, when you damage the property. Now, I've seen this done a lot of different ways, but the way that I think is most common is you pay the first month's rent, the last month's rent, and a security deposit. So when you go in to rent this apartment, if the apartment rents for $800 a month, you're paying $2,400 a month. $800 for the first month, $800 for the second month, or for the last month, I should say, and then $800 for the security deposit. But you need to pay special attention to what the deposit covers and what it doesn't cover. Many times the deposit will say it cannot be used to pay the last month's rent. But of course, if you've already paid that in your deposit, when you put the deposit down, right, you don't have to worry about that. But if you have not done that, if you've only paid the first month's rent and the security deposit, you can't usually use that to cover the rent for the last month. And then, of course, the rent is the amount of money you have to pay every month. Make sure you understand that any late payment that you make is going to be, there's going to be a penalty, and that's usually set forth in the lease. They will usually give you a 5-day grace period. So the rent is due on the first of the month, and you have the 5th to pay it. And if you don't pay it by the 5th, then it becomes delinquent. You get a 10% penalty or whatever it is. So that's really important to understand what your payment arrangements are and what the penalty arrangements are if you have a late payment. And then the other term I want to talk about is holdover, particularly a holdover tenant. That's somebody who stays past the term of the lease without having renewed the lease. So a tenancy relationship begins when a landlord or tenant agree on the terms of renting a property, and the agreement can be formalized in a lease, or it can be more informal in a month-to-month rental agreement. Now, most people think about leases as being something that protects the landlord, but it also protects the tenant because it gives them the right to possess that property for whatever term is set forth in the lease, so long as you strictly comply with the lease. And so it's really important, again, to read and understand what that lease says. So a lease is a binding legal document, and it specifies the duration of the rental amount, and any rules both parties must follow. There has been a trend in recent years, particularly if you're doing a 1-year lease, to specify that the rent for, let's say, you're going to rent for a year, 12 months, and the rent is $1,000 a month. The rental agreement or lease will specify that the rental is $12,000 to be paid in equal monthly installments of $1,000 each. And in a lot of states, if you agree to that, what happens is if you decide you need to move out after 4 months, well, you're still on the hook for that amount of money because you agreed to a 1-year lease period and you agreed to an amount of money for the rental, which was this great sum, the larger sum of $12,000. Now, there are some rules around mitigation of damages that come into play in those situations, but again, you need to be sure what you're agreeing to when you look at something like that. And if you think you might have to pack up and move because maybe you're graduating from college or maybe you're getting married and moving to a different city, you need to make sure you get the lease for the right amount of time and that you don't agree to a 1-year lease on the premise that, well, I can leave at anytime I want as long as I give them 30 days notice. Because unless that's spelled out in the clear terms of the lease, that's not the way the law works. Now, sometimes landlords will put things into their lease that are clearly prohibited by state law. They do this basically like a lock that keeps honest people honest. And if the lease says you can't do something, most people won't do it. But most people are rule followers, and not everybody is a rule follower. So it's against public policy for a landlord to include a provision that is prohibited by state law. And it can be an unfair or deceptive trade practice to do that. It can get the landlord in trouble with the state's Consumer Protection Act. For that reason, you want to look at the lease carefully, and if you have any doubt whatsoever about any provision, you take it to a lawyer and have the lawyer read through it, because the lawyer, if he knows the law in that area, he can spot something that's against state law, and he can call up the landlord and say, hey, you need to take this out of your lease, otherwise I'm reporting you. Again, it doesn't hurt to have a, strike that. Again, it doesn't hurt to have a lawyer look over these kinds of things specifically for that reason. So there have been a lot of cases throughout all the states that deal with these issues of leases and that sort of thing. In one case, a tenant sued because he didn't get the security deposit back. And that was true even though he had left the apartment in perfect condition. The court decided in favor of the tenant because the lease did not specify how the damages were to be deducted clearly and what the standard was for deducting the damages. So again, it's really important to know and read and understand the lease. A lot of times the landlord will tell you he knows what's in the lease when in most cases he probably doesn't. It was probably drafted by his lawyer, he made photocopies of it, and hasn't thought about it since the day he left the lawyer's office. Now, because a lease protects the tenant and the landlord, there is a separate form called month-to-month. And month-to-month rental agreements are rental agreements that renew each month. It offers flexibility for both the landlord and the tenant. However, it also means that either party can terminate the agreement with proper notice, typically 30 days. Now, this period is often set by statute, and sometimes it's not always easy to calculate. Now, there was a case where a landlord tried to evict a tenant with only 1 week's notice, and the court ruled that the landlord had to provide the full 30 days notice as per the state's month-to-month rental laws. But that period, again, can be difficult to calculate. Let's suppose that you are in a month-to-month rental process and the rent is due and payable on the first day of the month. And then you realize on the 5th day of the month that you're going to need to be out of town and leave on the 5th day of the next month. So you tell the landlord on the 5th day of the month, hey, I'm out of here on the 5th of next month. This is your 30 days notice. The landlord has every right to say, no, you have to give me 30 days notice from the date of the rental date. So if you are going to leave on the 5th of next month, you needed to give me the notice on the 1st of this month, and you didn't do that. And so for that reason, guess what? You're going to be on the hook for the rent next month. And again, that is subject to some mitigation of damages principles too, which we'll talk about here in a moment. So that's a real problem with month-to-month leases. And of course, the other problem with month-to-month leases is you could have been in the lease for 30 days and the landlord says, hey, in the next month, you're out of here. You hardly even got time to set up your utilities before you're moving again. And again, that can make you look kind of flighty to the credit bureaus and to people who may want to loan you money in the future. Now let's talk about holdover tenants. A holdover tenant stays in a rental property after the lease has expired. In many jurisdictions, if the landlord accepts rent after the lease ends, the tenancy becomes month to month unless a different result is specified in the lease. So in one scenario, a tenant stayed beyond their lease without paying rent. The landlord filed for eviction and the court supported the landlord since the tenant didn't make any payments and had no new agreement to cover his lease, or what would have been his month-to-month rentals. Now let's talk a little bit about the eviction process. Eviction is a legal process used to remove a tenant from a property. Now, the common reasons include non-payment of rent, which is probably number one, or violating the lease's terms. You tell the people that you have a salamander as your pet, and they say, oh, okay, yeah, no security deposits can be necessary for that. And then you bring in a Labrador Retriever. Again, they're definitely going to be upset about that. If you break the rules, They're within their rights to tell you to hit the road. The first thing they do is they issue you a notice to quit. It says to the tenant, okay, you've had this problem. I'm giving you 10 days to fix it, or you need to leave. And if you don't fix it, then a lot of places require a second notice to quit that says you have 10 days to vacate these premises or we're going to sue you. If they don't move out, then they file an eviction lawsuit. And the landlord can file the lawsuit, and a lot of times it can take 6 months for that to go through the court system. And if the tenant gets a lawyer and pushes back and fights against it, you can be a year in the property without paying any rent. And you probably think that you're being pretty smart because you're not paying rent, but if you're not putting that money aside into escrow to hold on to so you can pay when the judgment comes in, it's not a very smart idea. The eviction is more likely than not going to be allowed in most states. Some states during the pandemic had these moratoriums on enforcing this and preventing people from being evicted. A lot of people didn't pay rent during that period of time, and a lot of landlords lost a lot of money during that time. So that's why, just like they say, never a borrower or lender be, never landlord or tenant be if you can avoid it. You definitely want to own property because that's the safest way to possess it. Now, if you're evicted or if the eviction lawsuit is filed, there'll be a hearing. Both parties come in, present the evidence, and the judge makes a decision. If the judge agrees, the court rules in favor of the landlord, and eviction order is issued. Now, the eviction order is usually served by the sheriff, and the sheriff comes out and says, okay, you got to get out of here. If you don't get out of here, then what happens is the landlord goes back to the sheriff and says, I need you to evict my client or take my client. Here's the eviction order. So the sheriff goes in, and basically he's just there for security purposes. And people that the landlord hires take your stuff out and put it on the front lawn. And they have absolutely no obligation to protect your stuff if this happens while you're at work and people come by and say, "Ooh, nice TV," and take it with them. That's still theft, but the landlord isn't responsible for that because you abandoned that property inside his apartment. Now let's talk for a moment about rent and possession cases. Usually in some states there's a process called rent and possession, which is similar to an eviction. Essentially, that provides the landlord with a judgment for back rent. Here's $2,100 judgment for 3 months of rent, $700. And here's an order granting the landlord immediate possession. But here's the tricky part. In many situations, people apply for this rent and possession case after somebody has flown the coop. And so the reason to apply for it is to recover the rent that you were due under your lease. But this is where another catch-22 comes in. If the party that you are going to sue for rent and possession leaves on the 15th, and then at the end of the month you relet that apartment as the landlord, well, then you are only going to get 15 days worth of rent, the prorated rent, as your damages in the rent and possession case, because every landlord has an obligation to mitigate his damages as much as possible. Now, there was a case where a tenant was evicted for having unauthorized pets, and the court upheld the eviction because the tenant violated a lease term. In many cases, either not paying rent or violating lease provisions are what gets people evicted. Now, you can be evicted from a property for any reason set forth in the lease. If you violate a rule you set out in the lease, the landlord can serve you up with a notice to evict you. And even if your rent is paid up, if you've committed a violation, they can get rid of you. That's because a basic principle of property law is that an owner has the right to exclude others from possession of premises that he owns. And this is a right that courts will enforce. Now, let's say you're hit with a rental increase during the lease. If the ability to increase the rental amount is not set out in the lease, they cannot lawfully do that. Now, if they find you have a cat in violation of the pet policy, they can increase your deposit or they can evict you for a rule violation. The landlord has carte blanche really to select whatever remedy he wants to employ. Now, corporate landlords tend to be the worst because they employ basically mindless people to serve as their property managers. The folks have no authority to do or approve anything. They're bound by corporate rules, and they're really just there to take your check to the bank and make sure you're not parking more than 2 vehicles in their parking lot. So you have to be really careful about corporate rentals. If you're hit with a notice to quit, it is to your benefit to leave the property. If you wind up getting sued, that's going to go on your credit report and it's going to make it harder for you to rent property later. Whatever you do, don't destroy the property. I get it. You're upset. You don't want to leave. You're angry. But if you put a hole in the wall or you drop a lit cigarette on the floor and burn the rug, you're going to wind up paying for that. That's just the way the law works. If you waste somebody else's property, you're going to wind up paying damages to get it repaired and restored back to normal. So this has been a fairly in-depth tutorial on landlord-tenant law. I hope you understand that it's there to help you protect your rights when you're leasing property or when you are essentially leasing your property out to someone else. Always read the lease carefully. If you are a landowner and you wish to lease your property, always make sure that a lawyer drafts your lease so that it complies with your state laws. So that's what I have for you today. Thank you so much for watching. If you have any questions, drop them in the comments down below or email me at the address above. Like, share, subscribe, all those things all of us annoying YouTubers ask you to do. I'd love for you to do that if you feel compelled to become part of our channel here. That would be great. If you have the opportunity today, do something nice for somebody and then come on back down here tomorrow. Join us at the beach. I'll still be gone probably, but I'll have something else for you. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.